Even Dr. Eastman knew his theory didn't hold water. Mr. Jacob, you discussed and even debated this theory at length with Dr. Eastman. Did Dr. Eastman ever tell you what he thought the US Supreme Court would do if it had to decide this issue?
Yes. We had an extended discussion, an hour and a half to 2 hours on January 5th. And when I pressed him on the point, I said, John, if the vice president did what you were asking him to do, we would lose 9-0 in the Supreme Court, wouldn't we? And he initially started it, well, I think maybe you would lose only 7-2. And after some further discussion, acknowledged, well, yeah, you're right, we would lose 9-0.
I appreciate that. In our investigation, the Select Committee has obtained evidence suggesting that Dr. Eastman never really believed his own theory. Let me explain. On the screen, you can see a draft letter to the president from October 2020. In this letter, an idea was proposed that the vice president could determine which electors to count at the joint session of Congress. But the person writing in blue eviscerates that argument. The person who wrote the comments in blue wrote, quote, the 12th Amendment only says that the President of the Senate opens the ballots in the joint session and then, in the passive voice, that the votes shall then be counted. The comments in blue further state, nowhere does it suggest that the President of the Senate gets to make the determination on his own. Judge Luttig, does it surprise you that the author of those comments in blue was in fact John Eastman?
Yes, it does, Congressman. But let me, watching this unfold, let me try to unpack what was at the root of what I have called the blueprint to overturn the 2020 election. And it is this, and I had foreshadowed this answer in my earlier testimony to Congresswoman Cheney. Mr. Eastman, from the beginning, said to the president that there was both legal as well as historical precedent for the vice president to overturn the election. And what we've heard today, I believe, is what happened within the White House and elsewhere as all the players led by Mr. Eastman got wrapped around the axle by the historical evidence claim by Mr. Eastman. Let me explain very simply. This is what I said would require a digression that I would be glad to undertake if you wished. In short, if I had been advising the Vice President of the United States on January 6th, and even if then Vice President Jefferson and even then Vice President John Adams and even then Vice President Richard Nixon had done exactly what the President of the United States wanted his Vice President to do. I would have laid my body across the road before I would have let the vice president overturn the 2020 election on the basis of that historical precedent. But what this body needs to know, and now America needs to know, is that that was the centerpiece of the plan to overturn the 2020 election. It was the historical precedent in the years and with the vice presidents that I named, as Congressman Raskin understands well. And the effort by Mr. Eastman and others was to drive that historical precedent up to and under that single sentence, single pristine sentence in the 12th Amendment to the United States Constitution, taking advantage of, if you will, what many have said is the inartful wording of that sentence in the 12th Amendment. Scholars before 2020 would have used that historical precedent to argue not that Vice President Pence could overturn the 2020 election by accepting non-certified state electoral votes, but they would have made arguments as to some substantive, not merely procedural, authority possessed by the Vice President of the United States on the statutorily prescribed day for counting the Electoral College votes. This is constitutional mischief.
Judge, I think that's a good point, and I think it kind of begs the question that if the vice president had this power to determine the outcome of a presidential election, why hasn't it ever been used before? Why hasn't that ever happened? Why hasn't a vice president simply rejected the outcome of an election and declared someone else the winner? And instead, as the chairman mentioned in his opening, for over 2 centuries, vice presidents have presided over the joint sessions of Congress in a purely ceremonial role. This even includes, as Mr. Jacob mentioned, Vice President Al Gore. For those of us who are old enough to remember, the 2000 election came down to one state, Florida. There were weeks of recounts and litigation after the election, and Al Gore conceded. Of course, Al Gore was vice president at the time, but he never suggested that he could simply declare himself the winner of the 2000 election when he presided over the counting of the electoral votes. Let's hear what Vice President Gore said when he described the situation he faced in 2000.
Importance of the United States of America in all of human history. In Lincoln's phrase, we still are the last best hope of humankind. And the choice between one's own disappointment in your personal career and upholding the noble traditions of America's democracy is a pretty easy choice when it comes down to it.
Mr. Jacob, did Dr. Eastman say whether he would want other vice presidents such as Al Gore after the 2000 election or Kamala Harris after the 2024 election to have the power to decide the outcome of the election?
So this was one of the many points that we discussed on January 5th. He had come into that meeting trying to persuade us that there was some validity to his theory. I viewed it as my objective to persuade him to acknowledge he was just wrong. And I thought this had to be one of the most powerful arguments. I mean, John, back in 2000, you weren't jumping up and saying Al Gore had this authority to do that. You would not want Kamala Harris to be able to exercise that kind of authority in 2024 when I hope Republicans will win the election, and I know you hope that too, John. And he said, absolutely. Al Gore did not have a basis to do it in 2000. Kamala Harris shouldn't be able to do it in 2024, but I think you should do it today.
Mark Short told the Select Committee that Vice President Pence consulted with one of his predecessors, Vice President Dan Quayle, regarding the role of the Vice President. Vice President Quayle confirmed Pence's view that the role was purely ceremonial. Mr. Short also told the committee that he, Mr. Short, received a call from former House Speaker Paul Ryan. Here is Mr. Short's description of his conversation with Speaker Ryan.
Speaker Ryan wanted to call and say, you know, you don't have any greater authority. And I said to him, Mr. Speaker, you know, Mike, you know, he doesn't, you know, he recognizes that. And we sort of laughed about it, and he said, I get it. And he later spoke to the vice president, too, to, I think, have the same conversation.
Fortunately for the fate of our republic, Vice President Pence refused to go along with President Trump's demands that he determine the outcome of the presidential election. Mr. Jacob, what was the Vice President's reaction when you discussed with him the theory that the Vice President could decide the outcome of the election?
Congressman, as I've testified, the Vice President's first instinct was that there was no way that any one person, particularly the Vice President, who is on the ticket and has a vested outcome in the election, could possibly have the authority to decide it by rejecting electors or to decisively alter the outcome by suspending the joint session for the first time in history in order to try to get a different outcome from state legislatures.